Senator Ludlam.
Thanks, Mr Deputy President. I rise to add the Greens' support for this bill and to acknowledge Senator Singh for bringing this matter before us today. This is very strongly in line with Greens policy, and in fact we, in the run-up to the election last September, announced and launched a digital rights package that had mandatory data breach notification as one of its components. This is a bill that was on the Senate notice paper before the last election, and my understanding at that time had been that the opposition in fact supported it. The then opposition, now government, supported it. This is, it's a shame that Senator Back's left us. I've got a lot of time for Senator Back, but I did find his contribution somewhat puzzling. Admonishing Senator Singh for somehow not giving people enough advance warning that this matter was being brought forward. It's been on the notice paper for years. It's a matter that's been canvassed certainly as long as I've been involved in this field, and as previous senators who've contributed to the debate have outlined, it's a matter of basic common sense. If a service provider or an organisation that you have trusted with private information that can range from anything from trivial personal details all the way up to your medical records, your credit card, and quite intimate material, if the organisation loses control of that, you have a right to know. And I would have thought that was something that the Coalition, or the Liberal Party at least, with its supposed focus on the liberty and integrity of the individual, would have been falling over themselves to legislate. Nonetheless, it's come forward as a private senator's bill. I was puzzled when, after the election, the government didn't simply proceed with the matter. There are no significant voices raised in industry, maybe a little bit of grumbling, but the fact is I think most people working in this field in Australian industry context would be well aware that the reliability of the trust, the integrity of your business model depends on people trusting that their data is secure. Given that this is, so much of our private information has now been shifted online, you've effectively lost control over it. And so what you would hope that the people that you've entrusted it with would at the very least let you know if that material has been made insecure or in fact has been lost. It can range, data breach, the sort of stuff that we're talking about, can range from the inconvenient all the way up to the life-threatening. When the Department of Immigration let go of thousands of people's records not so long ago, that actually puts people's lives at risk. They had a right to know that, rather than finding out about it in the media. And it affects people in this building. The fact that we weren't told for quite a long period of time that allegedly, and there appear to be quite strong indications now that this is the case, that hackers working for the Chinese government had penetrated the mail servers of this building, affecting staff, senators, representatives and journalists working in here. And we weren't told. When Senator Singh closes the debate, hopefully later in the morning, I would be interested if she can spell out, because my reading of the way that this is drafted means that it is intended to catch organisations such as those that run the mail servers here at Parliament House. I think the framing is broad enough to capture those. I think anybody from, in any quarter of Australian society, whether they work in Parliament House or not, have a right to know if their private material and data has been compromised. Citizens absolutely have a right to privacy. That's something that is recognised globally, and yet what we see is something of a patchwork. Mandatory data breach notification does exist in various jurisdictions, but it's very unevenly applied. And I would draw senators' attention to the World Law Group's Global Guide to Data Breach Notifications, which they published in 2013, that outlines just how uneven the regulatory environment is around the world. And one thing that Australia could do, in taking a fairly strong stand about mandatory data breach notifications, is, apart from encouraging other countries around the world to step up as well, is that creates a competitive advantage. Data is mobile, it can be stored all over the place. So why would Australia not take a strong stand in that regard? That's something that to me feels almost self-evident. So I'd be interested, I think, when Senator Birmingham stands up, who is someone who's had quite a long association with these issues, can put in black and white the position of the government as to why on earth you wouldn't proceed with a matter like this. Citizens absolutely have a right to privacy, and the examples, even from the last couple of years, where quite large corporations, major companies and government departments have simply lost control of people's material, is almost too long to get into a 20-minute speech. Sony was one of the most high-profile, Telstra, First Super, ANZ Bank, and these are just examples from recent times. The Australian Privacy Commissioner in 2012 said it appeared that these sort of events were on the rise. The Australian Information Commissioner, Professor John McMillan, said that there is strong support for the notion that the government must treat data breach notification as a mandatory process, and that internationally the tide is moving in this direction. Now, he said that in 2012. It's not like this issue is new to this parliament. It's not, even in my view, particularly a complex matter, so I very much look forward to hearing the government's arguments for why it shouldn't proceed. If it's the usual parliamentary tactics where you take a good idea, come up with some fabricated reason why you can't pass it and then reintroduce it as a government bill, we see that happen from time to time. This is one instance where I wouldn't begrudge it as long as it gets done. As I say, citizens have a right to privacy, and corporations and powerful institutions and governments have an obligation to transparency, and that is something, I suppose, of the Cypherpunk Manifesto. And we see this government, particularly under this Attorney-General, as moving in the opposite direction, as annihilating privacy for ordinary people while withdrawing government operations behind a curtain of national security. And that, I think, perhaps that will come out in Senator Birmingham's comments as a reason to oppose this kind of bill. As I do want to acknowledge, while I have the floor, someone who has done more than most to advance these issues around personal privacy, data security, and also the obligation of governments and powerful institutions to transparency. It's 2 years today since Mr Julian Assange, an Australian citizen, entered the Ecuadorian embassy in Knightsbridge in London and threw himself on the mercy of the Ecuadorian government in a bid for asylum because he was not getting any protection or any help from the Australian government at the time. Since the change of government, we've seen absolutely no change in posture or policy from the incoming government. In fact, if anything, things have got substantially worse. But I do want to acknowledge Julian Assange, who has now spent 2 years in the close confines of a very small embassy premise, and I also want to put firmly on the record my thanks, gratitude on behalf of millions of Australians to the Ecuadorian President and the Ecuadorian authorities for taking this stand. While sometimes the debates in here may seem somewhat abstract, these are issues that affect us all, whether we like it or not. Everything that we do, in some sense, is mapped and recorded online, and the integrity of that material and our rights to its protection and our rights to privacy are something that should not simply be frittered away. And again, I thank Senator Singh for bringing this bill forward for debate and look forward to putting it to a vote and sending it to the other place for consideration.